Hola, buen dia. Hi, everybody. My name is Antoni Abat in Ninet, and I am a Maria Zambrano Fellowship at the University Autónoma of Barcelona, and also a visiting professor of constitutional law and legal theory at the Hebrew University of Jerusalem. So I'm doing this short video to introduce my last edited book, which is Constitutional Law and Politics of Secession. This book has been published by Routledge, and I had the tremendous pleasure to work with a bunch of authors who are expertise on different topics that we are analyzing from different perspectives: legal theory, strict constitutional law, but also social legal approaches on both concepts. We offer a theoretical but also an empirical approach to the domain, and also how both concepts, let's say constitutions and constitutionalism, on the one hand, and on the other hand, secession, which is different of self-determination. We are analyzing these both concepts also along the book. So how they are epistemological construct and how they are related. So the first thing that I wanted to say is that this is not an apology in the sense of the ancient Greek word of explaining that we have a right to do something, right? I remember, for example, Aristides, the first Greeks, going to the Roman courts saying an apologetis, right? An apology in order to demonstrate that they have a right. So what I want to say is that this book is offering different perspectives from a very plural visions. So some of the authors are stating on the need of constitutional accommodate. Others believe that constitutions are not the place to accommodate. Others authors are also offering different solutions in the terms of how to deal with the concept of secession. So we try to offer a very plural scenarios and a very plural visions on the topic of secession. So the book is basically divided in four main parts. The first part is an epistemological construction where Professor Oklovich, Sanford Levinson, and myself, we are building up from different perspectives the theoretical aspects of the secession and constitutionalism. This, I will say, is the most theoretical section of the book, and it helps in order to then construct the most empirical aspects that we are also dealing with. The second section of the book, I need to check it because it's a very long book, is we entitled Constitutional Accommodation of Secession, where Professor Giuseppe Martinico deals with the relations of constituent power and constitutionalism. We also have the procedural aspects and model proposed by Miodrag Jovanovic. Then we have a Martushnet Secession and Policy Autonomy and Recognition, which deals how constitutions are dealing with the issue of secession, and how the constitutions can offer, let's say, different alternatives to secession in the constitutional framework. Then also within this second section of the book, we have Felix Mathieu and David Genet, Theory and Practice of Self-Determination in Multinational Democracies. This is a more empirical and comparative contribution where the authors are dealing with democracies and how these democracies has react to secession claims and secessionist claims. Then we have Natalia Morales and Francisca Paul Jimenez contribution with this deals with the Chilean 2022 constitutional draft, and in the light of the secessional claims and the indigenous people rights. So this chapter is dealing, as I said, with the indigenous claims and how these claims were attached within the whole constitutional draft in Chile, the debates and the outcome of the draft, how that was affected or not by the indigenous claims in the Chilean case scenario. Then we go to the part 3, which is federalism, autonomy, and secession, where we have a specialist on, I will say, federalist theory, like Professor Erika Arban, dealing with federalism and secession, and how constitutions address from a federal perspective the claim of secessions. We go then with a more also theoretical but also more empirical and scenario focused Maya Sahasic paper or contribution on Bosnia and Herzegovina, and how the multi-level constitutionalism and diversity is addressed in this chapter. And finally, in this third section of the book, we have Hili Modric Evenken, that she's dealing with the Arab Arab minority in Israel, and different constitutional possibilities in order to offer an alternative possibility to secessionist claims within Israel. The last section of the book is deals with international regulation and mediation of secession, meaning that we are jumping from the constitutional accommodation to a federalism, and then we go to the international scenario, and most let's say center in the EU. In the EU role in terms to accommodate secessionist claims of different subnational entities within the European Union. We have the first contribution in this last section is by Jose Alberto Acevedo Lopez and Caterina Santos Botello, where they are building bridges and Janus faces secession. They are analyzing from an historical constitutional perspective the Portuguese case and how Portugal has been addressed during his young constitutional history, the potential claims of secession, especially after the process of independence of the African colonies in the case of Portugal, not only the African but also East Timor in Asia. Right, then we jump to more focus on Catalonia. This is Hector López Bufilla paper and contribution, and how the role of self-determination here. He's playing with the concept of self-determination and to distinguish with secession, external self-determination. So he's doing also a theoretical framework, and then he analyzes the case of Catalonia within the EU legal and political scenario. Then we have Pau Busacoma Busquets' regulation of secession, which he's also addressing from international law perspective, not only with the EU. He overcomes the EU framework, but he's addressing and considering that the international law should has an accommodation, a normalization of the process of secession, and how to do so in order to really enable an effectiveness of this concept. Finally, we end with a case which is the case of Africa, is Ethiopia, and the case of the Tigray by Meretapti Yaye, and he's addressing how the Ethiopian constitutional system answered the claims of the Tigray and other secession claims within the case of Ethiopia and Eritrea. So this is the book. I think it's really holistic is an holistic approach to the concept of secession with new insights, and also providing both theoretical and empirical cases. Thank you very much, and I hope you like it. Thank you.